tonight we are having a discussion on the Right to Information Bill, and I've been asking some questions of myself, whether or not our governments are afraid to be held more accountable to us, we who vote them into power and we for whom they hold office in trust. You must have heard that the Right to Information Bill has become a very topical issue, attracting serious discussion in the country of late. Well, I've got in the studio here the people who've pioneered it, those in Parliament who have been involved in ensuring that this bill sees the light of day and who have been accused of feet dragging in the process. I am talking about the people who really matter in the process. My guest in the studio tonight are coordinator of the Coalition on the Right to Information Bill, Nana Oye-Letha. Good evening and welcome to the show.
Good evening, Samson.
Okay, I also have in the studio Chumesi Appiah. He is Felix Chumesi Appiah. He is the chairman of Parliament's Joint Committee on Constitution, Legal and Communications. You're welcome, Honorable.
Thank you very much.
All right, and also to my extreme left is lawyer Akoto Ampao. He is also a member of the National Media Commission. Good evening and welcome, sir.
Thank you. Good evening.
Good to have you. And by way of introduction, I'm sure that by now you have the information that this Right to Information Bill has been in the works for almost a decade now and has been with our legislators for almost 2 years now, but still has not become law. How important is this bill, and when are we likely to see this bill turned into law so that you and I can have the information we deserve to have without any hindrance? I would like to start straight away with you, Nana. You haven't heard this week in very blunt terms accusing the majority leader of Parliament, Cletus Avoka, of having gotten it wrong by trying to suggest that it is the coalition that has not provided some important information that it ought to have provided to facilitate the passage of this bill. What is going on?
Yes. When you analyze the statements of Majority Leader of Parliament, Honorable Cletus Avoka, over, let's say, the past few weeks in the media, you'd realize that he's been shifting the post. First, it was a statement about the Right to Information Bill not being a priority for Parliament. He was asked about it. He denied that he made such a statement, but the recordings are there. Then he convenes a press conference and states that one of the reasons why the bill has not been passed is that the Right to Information Coalition have not been able to submit some documents to the Joint Committee of Parliament to enable them finish their work. And our position is that do not pass the buck. We as civil society assist Parliament and other stakeholders as far as the legislative making process is concerned. It is the state responsibility and duty of Parliament to pass law. So you cannot blame any other person if you have been asked why you have not passed the bill.
But is it really not the case that you are supposed to make a certain submission after the Parliament group went around the country to collate views and it became apparent that there was the need to hold on and to have a certain input? Is it not the case really that you have also delayed in making that information available?
We have not delayed in making that information available. In the first place, Parliament have not requested for the information. We offered to provide expert advice and opinion on certain contentious clauses in the bill. an expert, that is Mr. Akoto-Ampah, was commissioned by the World Bank to prepare that document. It was prepared and forwarded to the World Bank. That was where our responsibility ended as a coalition.
Okay. Now, I will return to you later and for us to talk about some of the contentious issues. I've heard you speak about them at certain times. Okay. Okay.
Which is that this request that the coalition or an expert provide further information on these contentious sections was very recent. It was as recent as April or thereabout. So, I mean, in the assessment of the time it's taken, you can't say that the 1 month is what is responsible for the 2 years.
But I have heard some of you speak about these contentious matters far back.
Yeah.
Okay. Now, let's get into a bit of understanding what these issues are, which require the expert, advice. If I'll start with you, Nana.
Yes, one contentious issue is the exemption clauses in the bill. We have about 17 or so exemption clauses. That is information that will not be disclosed to members of the public. The coalition is saying that there are too many exemptions and Parliament wants some form of direction as to the exemption clauses that they can waive and those that would be necessary for good governance and then also for national security and the national interests. There's also the issue of the length of time and whether or not as citizens of Ghana we should pay fees, whether we should pay when we go and request for information, we should pay, because some members of Parliament and some members of the public are of the view that this is a human right and a constitutional right that we have to request for information. So why do we need to pay? Others are of the view that retrieving that information comes at a cost. And so who would bear that cost? There's also the issue of poverty. So these are some of the contentious issues.
I'll stay with you a little longer on the contentious issues. 17 of them you have identified. Which ones are more pronounced and why you think that they should not be the issues that should not be disclosed? For example, there's been talk about military spending not being a matter that should always be disclosed, as it were. Yes, if Mr. Akoto-Ampah can take that one.
Well, I think that part of the problem about the exemptions is that some of the clauses are not subjected to what we say the harm test. In other words, they are blanket exemptions. So they simply say, for instance, that all information in the custody of the security and intelligence agencies or created by them is exempt.
All information.
That's how it is. And our critique of that provision is that it is not all information that they hold, the disclosure of which would cause any harm to national security. So there ought to be a harm test which says that if that the disclosure of that information would prejudice national security, then it should be, how do you call it?
Can you demonstrate that, for example? What kind of information which is security related would be dangerous to have in the public domain?
Or if, for instance, the security agencies have information that there is an attempt to sabotage an important installation and they are following that quietly. Of course, this is not information. What they are doing in terms of taking the necessary security measures to apprehend the culprits, it's not information that should be disclosed.
It's okay to exempt that. Yes. Okay. Now, we'll return to a little more discussion around the exemption clauses and also the time, the duration, and the payment that I've heard Nana speak about a number of times. But Honorable Chumesi Apia, your committee, you went around the country, you took views of the public, and in the end you were satisfied that you had an almost a sacrosanct document, and subsequently you decided that there was a need for expert advice. And the question now that is being asked is that the posture then was as if you were really committed to having the bill pass quickly, but suddenly it appears you are not really interested in having it come out as quickly as you indicated. That is
obviously not true. And I'm saying it's not true because after we have collected the views. Now, if I should tell you, the state where the bill is, that's traveled to its very advanced state. Now, what we're doing is to try to sterilize, so to speak, the views and the opinion that we collected from the public, so as to make sure that when we are able to do that, we can then finalize our report and then put it before the whole House for passage. So it is not true that, yes, we said we're committed and now we appear to be dragging feet. That is not true.
When did the committee finish its work?
Say again?
When did the committee finish its work?
We haven't finished our work. What we say is that we have done the tour. The last time we met was to try to sterilize some of this issue, like sanitize them, make sure that, I mean, somebody will get up and say something that you as a lawyer may not, oh, maybe he wanted to say it this way, but he couldn't say it that way. Can we put it this way for the person, and then let's lay it so that it will all encompassing. We didn't just travel around the country just to go for a tour or just to go for sightseeing. One for this candidate, like you said, to collect views, to make sure that we enrich the bill with all these views. Indeed, Nana did mention some of these things that we're talking about. One, I agree with her that the exemption issue came up. There are those who believe that there are too much exemption. There are also those who believe that even the exemptions are limited. There are also, we have even suggested a recommendation that even Parliament itself should be exempted. Because there's not for any reason that we hold closed door meetings. Typical example is one when we had the problem with our national frontier with La Côte d'Ivoire. We held a closed door meeting. If we wanted the public to know what the outcome or the discussion we had, would they ask the press to go out? So such meetings that we hold, there is no view, in the view of certain people, that it should also be exempt. Now, so we cannot take just one side. And let me come back to this paper that Nana and then my good lawyer is talking about. I heard Nana, and not that she said it, I am aware that she started with this bill long ago, as far back in 2006, thereabout. Even before this bill came out, I knew that she knew the provisions clause by clause. So this idea that, oh, the idea that we should even submit a paper or make recommendation just come in April, I beg to differ. And even before then, before even the tour, we met at the Kofi Annan ICT Center.
I thought she was referring to the point at which one ought to have been commissioned.
No, they themselves.
When they were
Listen to me, they themselves. They hosted the committee, the joint committee, at Kofi Annan Center, where they gave us some leaflet, and then promised that a more detailed document will come to us. What they gave us was some leaflet. I mean, the threefold leaflet, that was what you gave us, taking certain points. But we couldn't have all the explanation at that time, and that a more detailed document will be submitted to us.
But your own committee, is it not taking too long for you to finish what you have to do?
What we're saying is that we didn't go for a tour for sightseeing. We went for a tour to collect views. Like I said, we're trying to polish what the public gave to us.
How long should it take you to do that?
It should take us a bit of time. We are saying that you have, in one breath, she is talking about exemptions. And it's indeed true, exemptions come up. Other people are saying that the sanctions should remain. I mean, my friendly lawyer is talking about, like, for instance, security matters. The others who are saying that, yes, he might be right. We should exempt operational and tactical matters. Maybe the other matters can be put forward. There are also people who are saying that, look, if you want to put operational and tactical matters, maybe strategic matters will matter too much. So we need to, when we say expert, we are not only asking the coalition to be the only expert to give us a paper. For instance, if you talk about security matters, well, we have Kofi Annan International Peacekeeping Center, for instance. We have approached them. We want to understand, you know, I understand tactical and operational matters. Okay, but there are certain other members of Parliament who don't even understand what tactical operational matters are.
What are they?
I want to get who explain it more to
No,
you.
at this time we are not asking for disclosure of any sensitive or security matter. Tell us, what are tactical operational matters?
No, later I will explain. Now the fee paying. There are three arguments. There's one that said that because it is a right enshrined in the Constitution, why should I pay for it? So they think that we should not pay. And that fee paying will become a barrier to some class of people just because they cannot afford the money. Then it means that they cannot obtain certain information that they think is fundamental to their human right. There's another group of people who say that there's now free lunch in this world. And that if you're going to ask for information that will take 2 reams of papers, somebody must pay for it, probably in a toner. There's another group that said that, well, somebody should pay, but it shouldn't be me. Let's even see if government... I'm coming. Let's even see if government can put maybe some tax somewhere, maybe 1 pesewa on a liter of petrol you buy, and then that should be used to take care of them. But we are telling these people that, look, when it comes to the taxes, I have no power as chairman of the committee, and I don't think the majority leader has power, or even the minority leader, or Madam Speaker, to introduce taxes in this country. You understand? So it means that if we want to adopt the third position, we must go back to the executive to do that. They either bring another subsidiary legislation to come and do that, or within the framework of the LI that to do that. So now I'm coming. The duration also came up. That why should it take me? Is it 7, 14, and 21 for me to get the information?
151 days.
Yeah, you know, this is a come up. Now even after apart from the duration, they also spoke about who decides. The bill says that when you go to request for the information officer can decide at that point in time to tell you, look, I can give you this information. And why should? And then there are provisions made for you to appeal. You go to the High Court. If the High Court says no, and people are also arguing that if you also do that, then people who cannot afford to hire lawyers like my good friend Akutapa cannot, or now a little for that matter, cannot obtain information. You know, or maybe your good self. I think that provision is meant just to create job for the lawyers, but let's leave it there. Maybe that one you didn't even mention it because you know that is
okay. Okay, so, Honorable, sorry, but hold it there briefly. You're on PM Express here on your Joy News channel on Multi TV. My guest Felix Chumesi appear. He is the chairman of Parliament's Joint Committee.
Point of correction. I'm the chairman of the Select Committee on Communications.
Chairman of the Select Committee on Communications. Okay, thank you very much for that correction. And Nana Oyelitha, you know her. She is a well-spoken advocate, and she is also the coordinator of the coalition for pushing for the right to information bill. Also, lawyer Akoto Ampao, he has been at the forefront of this bill as well, and he is a member of the National Media Commission. Of course, your views are also welcome. Your comments, your questions, you can send us a text 1760 on all networks. And like I said, I'll begin with you, Mr. Akoto Ampao. So, right to information bill.
Let me finish this.
I'll return to that. I'll return to that. Right to information bill. Why is it so important?
Well, indeed, as far back as 1946, the UN General Assembly was unanimous in its recognition that the right to information bill, or the right to information, was the touchstone for the enjoyment of all other fundamental rights. And this is so because that right ensures transparency and openness in the processes of governance. It provides citizens with all the necessary information that they require to participate actively in the affairs of their country and public affairs generally. It also, as you very well know, is an important mechanism to check and expose corruption, which is a major, major problem in our societies. Then again, the right to information provides the means by which ordinary citizens, empowered by information, can assert and enforce their rights. So, for instance, if a district assembly has been voted some money to provide a school or a medical facility for community, with the necessary education, that community can access the information, exactly how much has been given, who the contractors are, what are the timelines for the contractor to finish putting up the school or medical facility. And with that information, they can then bring pressure to bear on both the district assembly and the contractor to account to them as citizens who actually under the Constitution are sovereign.
Fantastic. So that in the end, my right to the information, getting the information is not at the discretion of the public officer who will decide that, you know, I don't think you deserve to have this information and all, but you have a right to that information in the first place. Nanawe?
Yes, it will not be at the discretion to an extent. Number one, according to the law, the bill, I do not have to give a reason. I do not have to tell the information officer why I need that information. That is why it's important to have the legal framework so that the parameters are drawn very clearly. That yes, I can request for information from the Accra Metropolitan Authority. I can request for this type of information, but I cannot, I don't have to give any reasons, but I cannot request for this type of information. As the situation is now, I went to the ministry, we wrote to and asked for some reports from the Ghana Health Service, and we were told that no, we cannot have those reports. But if we had the right to information, then if that information was not exempt, then we could say we are entitled to that information under this law, and the Ghana Health Service would have been compelled to give us that law. If they did not give us the law, we would have the reports, would have the right to appeal to the minister and then subsequently to the Supreme Court or whatever. So at least that this law gives us that legal framework. If I don't have any water where I live, in Nigeria or Ogbojo, I can go and ask information. When are you going to expand our water distribution system to this area? So it's very basic information. It's not just something that has to do with the media. It's for every Ghanaian, everybody living in Ghana.
But the question has also been posed about how we store information, as it were. We don't seem to have the capacity at the various levels of government institutions to be able to have, you know, a systematic process by which information is kept. So you may not have the information at all.
That is true, but that's why one of the proposals we are making to further enrich the current bill is to place on every public institution an obligation to train information officers to provide the necessary equipment and infrastructure for the creation, maintenance, and easy retrieval of information. So that you don't simply have a law which says that people have a right to information when the information is not properly kept. But that there's an imposition of an obligation on all public organizations to have proper record keeping. And that way, we are not only thereby servicing the general public, we are actually servicing institutions of government, even the cabinet and the president, because a time will come they would require a particular piece of information. And if there's a culture now, a newly developed culture of record keeping, they will be quickly able to access that kind of information.
All right. 1760. Send us your text messages, your questions also. They'll be answered.
Yeah, two things. Number one, we already have structures. We have the registries, we have the Public Records and Archives Department. And in the bill, the Office of the Head of Civil Service, the Attorney General, and the Public Services Commission are tasked with drawing up an implementation plan. The coalition is proposing, and we know that Parliament is friendly to that, on creating the Office of an Information Commissioner, instead of the Attorney General being the one to implement. So some of these provisions are already in the bill. We know Parliament is also looking at the possibility of passing the bill, but allowing for some time. Honorable will tell us how many years they are proposing. In the UK, it was 5 years. They passed the bill in 2000, and they used 5 years to create the structures. We can use less time.
All right.
But
in Nigeria, did they have anything like that? Because they have also passed theirs.
I don't think they had anything.
Okay.
Yes,
now, Honourable, my question to you is that you were talking about you finalizing some of the things that you have to be able to, now bring the bill into fruition as law.
Yeah.
But we have heard the majority leader suggest that in a matter of 2 weeks, this should be over.
Majority leader, I didn't hear him say that, and I don't think he will say that. He's one of the members of Parliament who take this bill very seriously. And now later will agree with me that at every meeting, even in Kumasi, in Tamale, Majority has found time to be present in our meeting as a committee. Even the minority chief whip, he also finds his time to come. He was with us in Tamale, Kumasi, in all this area. The last meeting we met, Majority Leader was seated there. He's not a member of the communications committee, but he came.
So
that tells you
what timelines are we looking at?
That tells you how serious the Majority Leader did this. By the way, he would have been let the comfort of his home to come and be with us. You understand? So he takes this very seriously. But I don't think he will talk about 2 weeks. I'm happy my good friend and Olita knows whatever Parliament does. He knows that we agree with them on certain portions. She knows, but she's said a lot of things that she knows we are doing. To that extent, she should be able to know that, look, we agree with you on this, we have done this, we have done B, maybe we'll see to finish. But I don't think we can take 2 weeks. We can take 2 weeks. Indeed, the reason why they were banned, and when I was talking to the lawyer Akatuan Powell at the reception, he asked me, oh, so when are you traveling? The reason why I think the World Bank, and I think that was the proposal day when they met us in Parliament, we met to them, was about data protection. That we know the UK to have passed this. We know Mexico have done this. We know India have done this. We know the Americans have done this. But we know that our bill makes explicit reference with data protection. One, say don't give this category of information. The same information about security services, the presidency, that they are making input to, that they're asking them to change, the data protection say don't give. And that has been passed already. We cannot go amended data protection. So what do we do to ensure that when it suits one, like you're saying, in your Ministry of Health or Kwalebu matter, you can rely on data protection. When it doesn't suit you, then you go to the right information. I'm coming. So that is the reason why they say, look, yes, you are about to finish your job, but we think in our own wisdom as World Bank that want to give you the last opportunity to look at either jurisdictions. And I think the minority leader mentioned that. A majority that did mention that with the interview, his interview with the press corps.
I'm still looking for a direct answer on what timelines we should be looking at. You wanted to make an intervention.
I am coming.
No,
let me just finish on that timeline. If I don't finish, you'll just
okay,
stop.
Finish that quickly.
Even if
but please
I'm
don't forget the
able to lay my
intervention you
report
intended
tomorrow,
to make.
It doesn't assure anybody, to be very honest with you, that the bill will be passed in 2 weeks' time. Majority leader should be a bit naive to say that, and I don't think he will say that.
He said that.
Even if I submit my report tomorrow, the House going to debate the bill. It might take 1 more year to debate it. Why? Let me give you a typical example. How many months did it take X years to be passed?
Well, the majority leader
yes,
said
he cannot say 2 weeks.
The committee
how
was
many days
did
the National Petroleum amendment bill? How many months did it take to be passed? Even after the report was ready. And I can give you several examples. Bills have been laid, and then it takes, even when the response are ready.
Majority leader, maybe he knows
but
something
he
you don't.
That.
Oh, when we present the bill with all the amendments, if we even agree to the coalition, the few things they've told us, both in private and at workshops, that let's amend all this portion. Let's take the security matter, let's do this, and then you go back into the floor. We are debating them. You tell me that we use just that thing, and everybody want to speak. or security matter, and we can use 2 weeks to pass a bill.
Okay, so for you, you think we should be looking at what timeline?
Within my purview. If you ask me when will the report be ready, maybe I could give you an idea. But if you ask me,
when will the report be ready?
No.
When will the report be ready?
Please.
I'm asking that question. When will the report be ready? I'm sure that your listeners and viewers will want to know.
No, when will the report be ready?
It is,
when will the report be ready?
My report even can be ready tomorrow, but even admitting it.
When? Not can be. When will the report be ready?
It will take
you see, it's very worrying that Parliament cannot even have...
As soon as
possible. The report will be ready.
Like 1 month?
As soon as possible.
Okay.
You see,
maybe before, maybe
for me, it's very worrying that the majority leader is saying one thing. He convenes a press conference. He said that...
And I don't think he will say that.
Press conference.
He said that the joint committee will submit its report within 2 weeks.
No.
He said that.
I heard him loud and clear on
Twitter. And it's very worrying that we have the chairperson of the joint committee and the committee on communications saying one thing here. The majority leader is also saying an entirely different thing. That is very worrying. So how are we sure that Parliament is committed to the right to information bill?
Attends almost every meeting that concerns this bill. As a majority leader, I don't think every majority leader will be doing that. He finds time every meeting. You've seen him at all times.
You have said that.
So that tells you how
that
serious
may not be in doubt, Honorable. That may not be in doubt. But you don't find it a bit difficult that you can't give any timeline when your committee will submit the report?
Excuse me, sir. I am a chair of a committee, and we are talking about democracy. I cannot decide single-handedly for the committee. We don't do that in Parliament.
You should have an idea.
No. If my report is ready.
Because you know where you are getting to.
The committee must meet and probably query the report.
You don't have any terms of reference for the committee, how you're supposed to go about your work?
The clerks, like I said, the clerks are working. They're seriously working. So that as soon as they report what the draft is ready, I'll convey a meeting.
When you give it to them, you give them some time. You give them time to work on it. Otherwise, they'll use the whole of the years to do.
No. We don't work in Parliament like that. You don't give assignment and say, finish in 3 days. We don't do that. No, we don't do that.
Oh, but I think you should be doing so.
No, we don't do
that.
Now,
Mr. Kutampa, you wanted to make an intervention. I want to hear what it is.
First of all, I think that it's important for us to underline the fact that the issues that have come up over the majority leader were created by his own statement.
That's true, I agree.
Yeah, so it's not as if people are not saying that he has not followed the activities of the joint committee.
Participated.
And participated. He was the one who, on his own volition, stated...
Lawyer, with all due respect, I don't think he will say that.
No.
I heard the interview on Joy when you played the tape, when the time you came in. I didn't hear him say in 2 weeks' time.
No. You're not listening. The lack not being the priority.
The discussion, yes. The priority.
When he also said it wasn't a priority. I don't think he said that.
He listed items that have been of priority, like the petroleum management bill and all.
So that's the first point I want to make. But coming back to the more fundamental issue, I think the whole idea of a right to information law is one to indicate the right of the citizen to information and place obligations, legal obligations, on public bodies to divulge information. 3, to circumscribe areas where information will not be disclosed. Now, and the whole idea of any serious right to information is that it takes primacy over all other laws that seek to restrict access to information, because that is the law dealing with that. So if you are drafting a data protection bill and law, you don't do it without taking into account, the principles and regime of a right to information bill.
All right.
So if Parliament has unfortunately rushed to pass a data protection law, whilst they are still working on the right to information. Then when the right to information is passed, the principles and provisions of that law would take primacy over the data protection law. Just as, for instance, currently we have the state, how do you call it, Secrets Act. It restricts certain information. You have the oath decree. That also restricts certain information. We have the Civil Service Act and regulations. Those two pieces of legislation also restrict access to information. What the Right to Information Bill, when passed into law, does is that all those laws will become subordinate to the Right to Information law. And indeed, if the Aegis Department and the Law Review Commission is doing its work well, then they must proceed then to review all those laws so as to make sure that they come into conformity with the Right to Information law. You know, so I think that it's very important for us to understand these relationships. And in all Right to Information legislation, it is stated that that law takes precedence over other legislation. The final thing that I want to make is that, yes, I think that we cannot dispute the fact that if you want to pass a good Right to Information law, you rush and pass any law, because when you do that, you are likely to create even more problems. However, the issue is to ensure that whilst you take time, you are actually making use of the time. If you wait for 1 year without acting, and then when the issue comes, you say that, oh, you need to take time to pass the law.
From where you sit,
yes.
Is that the attitude you seem to
suggest
is happening?
I think that we have reached a stage where the Joint Committee appears to be ready to push on. And I think that's a positive state. And I also want to make the point that even as we are very critical of the Joint Committee, we recognize that we are partners working towards the same objective. Now, what we need to ensure now is that there's no further foot dragging.
All right.
Because we will soon run into the heat of the campaign season. And this very important law would not be passed. We'll be entering 20 years after the passage, after the coming into force of the Constitution, which guarantees the right to information.
Let me see if I can get a direct very quick answer to this. Parliament rises when?
Somewhere in August, July, August, thereabouts.
Will the bill be passed by then?
I've told you earlier on that I don't decide for Parliament. We are 230 members of Parliament.
That it should be passed by then?
It is, of course. And I like the way I put it. Because why? There have never been any foot dragging. And Anolita is very much away. Within that 1 year, there have been several activities.
It's been 2 years.
Within that 2 years, there have been several activities. Why? We have had, several activities.
Frankly speaking,
several activities. So if the impression is created,
frankly speaking,
we are just sitting down and dragging feet, we're not doing anything.
Frankly speaking,
she's the first person to call me for video conferencing to Sierra Leone and to South Africa and to where, and I'll be there. And so you want the report?
No, frankly speaking,
say something
frankly
to you.
If you get the impression that we're not doing anything,
frankly speaking,
let Mr. Akutampa make that point.
Frankly speaking, I think that we all ought to be honest to recognize that it has taken the Joint Committee a little too long to prepare and finalize the report after the end of the nationwide consultations. I think that one we can all agree.
And of course, when you give the work to the clerks to work on it, you don't give them any timelines.
And the acceptance,
they'll go to sleep.
Not that they go to sleep. The clerks have been very busy working on this report.
It's human nature.
And
we like to work with timelines.
And I'm saying it. Yes, we work with timelines. When we did the consultation, we came back. Why? We have had several meetings with other stakeholders. And Lawyer Kotampa knows, Olita knows, even including the World Bank. They've come and brought us a paper. We want you to add A, B, C, D. After that, Nana Oyelita found it prudent to organize another workshop for us again in our data where were we very well. So every now and then something else comes up. So if it does come up, what do we do? When we invite us, we say we are not coming because we have given a deadline.
Honorable Chumisi, as far as you are concerned, we won't have this law.
We are working on the report.
We won't have
and
this law.
And as soon as possible, the report will be laid.
That's a good enough
as soon as possible.
I just want to make a final point that, you see, Honorable has indicated that the coalition has dallied in providing the inputs. I want it placed on record that as far back as 2006, the coalition produced about a 50 to 60 page book dealing with all the provisions. Please.
Just hold it. I'll give you the opportunity to react.
Dealing with every single clause of the bill at the time and making very concrete proposals. So it is not the case that we haven't done so. Okay. What we did subsequently, which the chair has referred to, was to provide a summary of that detailed thing in that pamphlet that he's talking about.
All right. Now, Nanoye, I'm interested in a certain aspect.
Let me just say something small to what he said.
Do that in 1 minute for me.
Yes, he just acknowledged. And yesterday, the World Bank called me yesterday and said, they believe that by this weekend, your submissions will be ready with them.
No, let me tell you that our submission was given to the World Bank as far back as 7th of May. Almost 2 weeks.
So they have a 2 weeks time.
Yes.
But it hasn't been given to us.
So we have actually discussed with them.
But we don't have it. And
listen, hold on.
Yeah.
That because they commissioned the thing, we couldn't just go ahead and give it to you. So we've talked to them and they've agreed that we can make them available to you. So by Monday, we are reproducing copies. Monday, we'll have all the copies available to you.
All the report that the class.
We'll see what excuse. What other excuse you come up with? We'll see. We'll see what excuse you come up with.
Look the excuses.
I'd like us to do a very quick exercise, and Lawyer Kotampa will take us through the duration, the period by which you can access information according to the bill as it stands.
Well, the provisions dealing with that are in Section 23 of the bill currently. And it states that when you make an application, the information officer has 21 working days, which comes up to maybe about 26 plus days to tell you whether or not the information will be given to you. And then thereafter, he has 14 days within which to give you the information if he intends to give you the information. And then there's a further provision that the information officer may, upon reasonable grounds, extend that 14 days by another 21 days. And there's a further clause which was introduced in, I think, 2009, just recently, because until then this was all. There's a further clause now that the minister responsible can extend it by another 90 days. So when you put all together, it's over 5 months, 151 days. And we are saying that in the modern information age, where information is time, and time is power, this will defeat the whole purpose of the bill.
So, for example, the first 21 days after the application, what is your proposal?
We are proposing anything between 10 and 14 days.
10 and 14 days?
Yes, because we think that whether they have the information or not, whether the information will be given or not, is a simple exercise of determining whether or not that is exempt information. So you don't need 21 days to determine whether the information that is being being requested for is exempt or not. It's actually a fairly simple exercise, you know.
No, it's not only that.
It's fairly
it's not only that. One is to look at whether it's exempt or not, and two is to look at the availability of the information.
Well,
yes. So it's not only you saying whether it's exempt or not. It's also you determining whether the information is available or not.
Yes. Like he says, you don't need 21 days to determine if the information is exempt.
Well, that is his opinion, but I'm only adding that it doesn't only say that go determine.
That's why I'm not saying that it should take 2 days, because really to determine whether it's exempt or not.
Okay, so you're proposing about 10 days for that.
10 to 14 days. Yes.
How about the 14 days?
The 14 days to give
it to you.
We think it's okay. Yeah.
Okay, and then if there's supposed to be a further extension by 21 days, that sounds reasonable within our record-keeping system. Nanoye doesn't seem to agree with the 21 days extension.
No, the additional days that the minister can extend.
That is what we are opposing.
90 days.
That is totally uncalled for.
Yes. I see.
In our view.
Okay, I've got some of your comments here. This is Keshe Clement. He says, I think our current leaders are doing more harm than good to this country. I think they also do not care about the future of Ghana. Bobling Gatinga writes, good intention, but some of us will also demand detailed relevance of such a bill vis-a-vis their current limitations. I have often heard that in some media organizations, true factual stories are often massaged by their leaders. Therefore, giving rights could even worsen the situation. Is the right to information bill actually meant to be free to access or free access to information? Is such law strong enough to operate in the private sector and multinational companies? Frankly, I think the Ghanaian media needs resources to actually unravel information, not right. I see, interesting view. But you see, Nanoye later was trying to draw your attention to the fact that this is not about media. It's about you and your right to the information as an individual. King Monta writes, sometimes you wonder whether the government is there to serve their own interest. The committee set up by Parliament has submitted a report to the House. Why this delay? This bill, when passed, would empower the citizen to ask questions on hidden issues when discovered. The bill must be passed with haste. Okay, he thinks that it really must be passed with haste. Justice Ezoa Aka writes, but even when we contribute, the government is not going to abide by my view. But I hope with multi-TV, all shall be well for Ghana. No, there are times we need information we can't have. So the bill is very important. Gideon Ochredakon writes, right to information can never be overthrown in any country which is at the very quest for development. But this, okay, let's be very careful what we say. I will not read the rest that you're saying. You think that the government will not pass it for reasons that are known to you. Anamala Umar Kabu, sorry, forgive me, says the right could have been passed, but the right to information bill could have been passed, but due to the incumbent and corrupt nature of this government, they delayed to pass the bill, which will expose their corrupt deeds. Okay, I'm sure that we can stick to the, the technical bits of the discussion that we're having. Amwatin Kusikweku writes, this government is not serious with the passage of this law, and they also made it a manifesto promise, so they should deliver. 7 December is around the corner. Edward Messiah writes, parliamentarians must work hard towards the passage of the Right to Information Bill to become law, to help initiate projects in the country. Nana, thank you for pushing the RTI law. Bonti Benjamin writes, a leader who has the political will can champion this bill to the latter for the growth and development of our human resource capacity. And I cannot see this in the current managers of Mother Ghana. Justice again writes, this government is pretending to be promise and fail. But 7th December will declare all they did. All right. Dixon Desire, right? Samson, do you know that the NDC government has received an unprecedented amount of loans than any government in the history of Ghana, and yet we don't know what they have used their money for? Okay. Will the passage of this bill give the opportunity to Ghanaians to be able to question the government how they use such money, since we all pay for loans? Well, that's a question. You have a legitimate question. But if you have been following the news, I'm sure that the loans that are being acquired, you are being told about the projects that they are being directed into. We have Bonti Benjamin and Dixon again. Please, let's have some other people contribute to the show as well. But in any case, we are just about wrapping up. And I would like to ask Nana Oyeleta this question. Do you sincerely believe in the comments of commitment that members of parliament are giving us about the Right Information Bill?
The issue is that we need to put pressure on parliament. As the people of Ghana, we need to put pressure on parliament to ensure that the bill is passed. And we don't want a bill that we can, or a law that we cannot work with. We want a law that will enhance transparency and accountability. We are moving as a country. We are now producing oil in commercial quantities. There's a need for government to be able to disclose information. And that is why we are urging Parliament to consider the recommendations that the coalition has made. They have all the points. We have articulated them very clearly. And like we said, it's going to be a political campaign issue. It's already a political campaign issue. Especially,
you'll be disappointed if the bill is not passed this year.
We would be very disappointed.
We will be
outraged. And we will hold the NDC accountable. Like we have said, they've put it in their manifesto. So we are going to follow them everywhere. That will be a failed promise. If they do not pass the bill, then that is a failed promise, and that would have implications for their political campaign.
You belong to the NDC, and this is not
unfortunate coming from a lawyer. Very, very unfortunate. Point number one, be it as campaign manifesto. The president has fulfilled his constitutional obligation by first and foremost introducing the bill. Unless, of course, a lawyer is telling me that the president should bypass or should, as it is, conflict the constitutional provision by pushing parliament. The president has no right whatsoever to tell us what to do. He has no right. If the bill is not passed, put the blame on parliament, but not the president. He's introduced the bill. That is all he can do. He's done it.
You belong to the NDC. You don't want to help the president in this project?
His constitutional promise. His manifesto promise. But first and foremost, introducing the bill.
All right.
If the bill is not passed, it's the work of parliament. Blame parliament. Don't blame NDC. Don't blame the president.
So are you going to channel your energies?